All right, so today we're diving deep into the world of Indian corporate law. You know, the kind of stuff that sounds dry as a bone, but can actually teach us a thing or two about navigating the business world.
That's right, and this one is a real nail-biter. It's got it all. Debt, legal battles, and even a glimmer of hope at the end. We're talking about perfect engine components, PVT LTD, or PECPL for short.
PPPL. So, for those of us who aren't fluent in engine parts, what's their story? What do they actually do?
Well, they were a pretty big deal in the Indian automotive industry. We're talking supplying engine parts to big names like Bajaj Auto and Tata Motors.
Oh, wow. So, big players in the game.
Exactly. And back in 2008, they managed to secure a significant loan from none other than the State Bank of India. They even put up some assets as collateral, just to sweeten the deal.
Seems pretty standard so far. So, what went wrong?
Well, here's where things get interesting. Just a year later, their account gets slapped with the dreaded NPA label non-performing asset.
Oh, that can't be good.
Not good at all. It's basically a giant red flag in the financial world.
So, what happens in India when a loan goes sour like that? Does the bank just come in and seize everything?
You'd think so, wouldn't you? But it's actually way more complicated than that. See, the Indian government, they've got this whole framework set up to encourage the revival of struggling companies.
Oh, really? So it's not just about cutting losses and moving on?
Not at all. It's seen as more beneficial for the overall economy, preserving jobs, minimizing losses for everyone involved.
Interesting. So it's about trying to find a way forward, not just hitting the eject button.
Yeah.
So what happened with PECPL? Did the State Bank of India just cut them loose after the MPA declaration?
Nope, not right away at least.
Yeah.
Instead, they tried something else. Actually, they, and later this group called Edelweiss Asset Reconstruction Company, they took over the debt. By the way, they tried restructuring the loans. Not once, but twice.
Whoa, two lifelines. They were really trying to make it work.
They were, once in 2014 and then again in 2017. But
I'm sensing a but coming. Those efforts didn't quite do the trick, did they?
you'd be right. Despite all that, PayCPL just couldn't seem to regain its financial footing.
So what happened next?
Well, this is where it gets juicy. In 2020, Edelweiss, who is now officially a secured financial creditor, decided they had to take more drastic action. They filed a petition to initiate insolvency proceedings against PayCPL.
Okay, so now we're talking serious legal action.
You got it. They were basically invoking India's insolvency and bankruptcy code, which, believe me, is a whole other beast. But essentially, they were taking legal action to try and recover their money.
So time for a courtroom showdown. I'm ready for the drama. What happened when Edelweiss filed their petition?
Well, get this. The first judgment actually went against them.
No way. Seriously, why? I mean, it's not like the debt just disappeared.
I know, right?
Yeah.
But here's the thing. The National Company Law Tribunal, or NCLT for short, they're the big dogs in India when it comes to insolvency cases. Well, they declared Edelweiss's claim as time-barred.
Time barred. What does that even mean in this context?
So basically, in India, like many other places, there's a time limit on when a creditor can take legal action to recover a debt.
Really? Even if the debt is still very much real?
Yep. And in this case, the NCLT decided that Edelweiss had waited too long after that initial NPA declaration back in 2009.
So even though PIS-TPL was clearly in debt, Edelweiss missed the deadline to do something about it. That seems a little harsh, doesn't it?
I know, it's a bit of a head-scratcher. But it all comes down to this concept of acknowledgement of debt, which gets really important as this case unfolds. Because Edelweiss argued that PICSPL hadn't just completely ignored the debt all those years.
Oh, okay. So PIS-TPL had at least acknowledged they owed the money.
Exactly. And that, my friend, is where things get really interesting.
So, PIS-CPL is in a tight spot, to say the least. Their debt is officially time-barred, at least according to the NCLT, but Edelweiss is arguing that PIS-CPL actually acknowledged the debt, which could reset the clock on that whole time limit thing. What kind of acknowledgement are we talking about here? Did they send a singing telegram or something?
Nothing quite so dramatic, unfortunately. It all boils down to those restructuring agreements Edelweiss sent over in 2014 and 2017.
Right, those lifelines we talked about earlier.
Exactly. See, PICPL didn't just ignore them, they actually signed those agreements. And according to Edelweiss, those signatures were as good as gold.
How so?
Yeah.
I mean, it's not like they paid back the debt in full, right?
True. But Edelweiss argued that by signing, PECPL was clearly acknowledging that the debt existed, and they were actively trying to deal with it. Even if they weren't making full payments, the act of signing those restructuring agreements showed they were aware of the debt and taking steps even if they weren't totally successful steps to address it.
So basically, by trying to work with Edelweiss, they accidentally gave Edelweiss more ammunition to use against them later on. Talk about a catch-22.
Exactly. And it didn't stop there. Remember how we talked about those all-important financial statements?
Right, every company's got them.
Well, PECPL, maybe without realizing the implications, kept listing their outstanding debt to Edelweiss in those statements, even as late as the 2018-2019 financial year.
So they were creating a paper trail, basically.
Precisely. And that paper trail would come back to haunt them in court.
Wow, so even though it seemed like Edelweiss might be out of options after that initial NCLT ruling, they still had some tricks up their sleeve. What did the appeals court have to say about all this?
Well, the National Company Law Appellate Tribunal, or NCLA as it's known in legal circles, they found Edelweiss's arguments pretty convincing.
Really? So they sided with Edelweiss?
They did. They overturned the NCLT's judgment and ruled in favor of Edelweiss, saying the claim wasn't time-barred after all.
So it all came down to those acknowledgments of debt, the signed agreements, the financial statements. It's like they say, the devil's in the details.
Absolutely. And to make their point even clearer, the NCLA even cited a landmark Supreme Court case to back up their decision. This case emphasized how even just a judgment or a certificate of recovery, which Edelweiss had, could effectively reset the clock on that all-important limitation period.
So a major victory for Edelweiss. But I'm guessing PEPL didn't just throw in the towel at that point, did they?
You know it. They decided to take their chances and appeal to the highest court in the land, the Indian Supreme Court.
Talk about a Hail Mary. Did the Supreme Court give them any relief?
Unfortunately for PEPL, the Supreme Court upheld the NCLAC's decision. They agreed that those acknowledgments of debt were enough to keep the claim alive.
Wow, so that was it. Game over for PEPL.
Well, not quite game over, but it did pave the way for the insolvency resolution process to begin.
Okay, so what does that actually mean? Paint me a picture of this resolution process.
So the court appoints an interim resolution professional, or IRP for short. Think of them as a kind of neutral referee overseeing the whole process.
Makes sense. So what does the IRP actually do?
Their job is to keep the company running as smoothly as possible during the insolvency proceedings, figure out who's owed what, and, most importantly, start looking for potential investors who might be interested in rescuing the company.
So they're like a combination of a caretaker, a detective, and a matchmaker all rolled into one.
Exactly. And in PCPL's case, this is where things start to get interesting again. Because a few potential white knights actually did emerge, each with their own ideas about how to save the company.
Oh, this just got good. Who are these potential saviors? Give me the rundown.
Well, the first one might surprise you. It was actually one of PCPL's own creditors, Shree Satya Minerals PVT Ltd.
Wait, really? One of the companies that PECL owed money to wanted to buy them out. Why would they do that?
Well, it's all about strategy. See, Shree Satya Minerals was what's known as an operational creditor. That means they had provided goods or services to PECPL raw materials, I believe, in this case.
Okay, so they were suppliers. How is that different from Edelweiss?
Edelweiss was a financial creditor, which is a whole other ballgame. They were primarily involved in loans and other financial dealings with PCPL.
Gotcha. So Shree Satya Minerals, as an operational creditor, decided to try and turn their receivables into, ownership of the whole company.
Exactly. They saw an opportunity to, shall we say, cut their losses and potentially gain control of a competitor in the process.
Bold move. Did it work? Did they manage to take over PTCPL?
Not quite. While the NCLT acknowledged their petition and even recognized their role in pushing PTCPL toward the insolvency process, they ultimately decided against giving Shree Satya Minerals control of the company.
So what happened then?
The NCLT stuck to their guns and appointed an independent professional, a guy named Vikas Prakash Gupta, as the interim resolution professional, that IRP we talked about earlier.
Makes sense. Got to keep things neutral. So, with Shree Satya Minerals out of the running, who else stepped up to the plate?
This is where it gets really interesting from a business perspective. Remember how PTCPL was a supplier to those big automakers?
Yeah, Bajaj Auto, Tata Motors, those guys.
Right. Well, one of those big players in the automotive world saw an opportunity in PCPL's troubles.
Let me guess. They swooped in with an offer to buy them out.
You got it. The company was Mayer Industries PVT Ltd., a major player in the automotive components world.
Wow, so not just a random investor, but a direct competitor. I bet that added a whole other layer of complexity to things.
You can say that again.
So Mayer Industries, PCPL's competitor, swoops in with a plan to save the day. Sounds like something out of a movie. But before we get to the Hollywood ending, What did Mayer Industries actually bring to the table? What was their grand plan to rescue PCPL?
Well, their plan was valued in a cool 17.07 crore rupees. Not exactly chump change.
Okay, so a decent chunk of change. But what did their plan actually entail?
Their idea was to basically absorb petty CPL into their own operations. Leverage PCPL's existing expertise. Their customer-based smart move, if you ask me.
Right, a classic case of turning a competitor's misfortune into a strategic advantage. But did their plan involve paying back all of PCPL's creditors? Edelweiss, those operational creditors, everyone?
Well, it's rarely that straightforward in the world of insolvency. These resolution plans, they're more like delicate balancing acts. It's about finding a way for the company to actually survive and function, while also making sure the creditors get something, even if it's not 100% of what they're owed.
Makes sense. So how did Mayer Industries plan to divvy up the pie?
Their plan laid out a payment schedule for the different types of creditors. They had separate categories for the operational creditors. Remember, those are the suppliers and employees. Then there were the unsecured financial creditors, meaning they didn't have any collateral backing up their claims. And then, of course, there was Edelweiss, the big kahuna, as the secured financial creditor.
Right, so they had to keep everyone happy, or at least somewhat satisfied.
Exactly. And interestingly enough, they actually offered to pay the operational creditors, those workers and suppliers, a pretty significant portion of what they were owed, 5.41 crore rupees.
Interesting. So they're prioritizing those folks.
Seems like it. And that's not just good PR, Keeping those folks happy, especially in a specialized industry like this, it can really pay off in the long run.
Reputation is everything. But at the end of the day, Edelweiss had the final say, right? Did Mayer Industries' plan manage to win them over?
It did. The committee of creditors in this case, it was basically just Edelweiss that gave their stamp of approval.
Wow, so they were convinced. So that's it then, right? PECL is saved.
Well, not so fast. Remember the NCLT. Those guys don't just rubber stamp things. They wanted to take a good, hard look at the plan before giving it their blessing.
So the final decision rested with the NCLT. What were they looking for?
Well, first and foremost, they wanted to make sure everything was done by the book. That Mayer Industries' plan checked all the boxes when it came to the insolvency and bankruptcy code. But they also dug deeper than that.
Okay, so what kind of digging did they do?
They wanted to be sure the plan was actually feasible, that it wasn't just some pie-in-the-sky idea that would fall apart in a year or two. They looked at Mayer Industries' own financials, their track record, basically making sure they had the means and the know-how to actually pull this off.
Due diligence, as they say. Anything else?
Oh yeah, they even looked into this one thing, kind of a head-scratcher at first. See, the proposed value of Mayer Industries' plan, it was actually slightly less than what PCPL would have gotten if they just liquidated all their assets.
Hold on, less. But wouldn't selling everything off, even at a fire sale price, bring in more money, at least in theory?
That's what I thought too. But turns out the law doesn't actually require the resolution plan to be worth more than the liquidation value. It's more about finding the best path forward for everyone involved, even if it means some creditors might have to take a bit of a haircut.
So it's not always just about squeezing every last rupee out of a failing company.
Exactly. It's a more holistic approach. They're looking at the long game here. But yeah, the NCLT has still had some convincing to do. What else was on their minds?
Right, so they're looking at the big picture, considering all the angles. What were their main priorities in making this decision?
They wanted to see if Mayer Industries' plan addressed the root causes of PECL's struggles. Were there management issues, operational inefficiencies? Were they just unlucky? They needed to be sure that this wasn't just a temporary fix, that PECL would actually be viable in the long run.
Makes sense. No point in going through all this, just to end up back at square one in a few years. So after all that scrutiny, after all those deliberations, what was the verdict?
Drum roll, please. The NCLT gave Mayer Industries' plan the thumbs up. The PECL was officially given a second chance. And you know what? The NCLT even went so far as to say how important it was to respect the Committee of Creditors' judgment in cases like this. They basically said, hey, these creditors, they're the ones with the skin in the game, so their opinion carries a lot of weight.
So in the end, it was a happy ending for PECL.
You could say that. They were pulled back from the brink of collapse, all thanks to this whole insolvency process.
It's a great example of how the system, at least in theory, is designed not just to punish companies that are struggling, but to actually help them get back on their feet.
Exactly. And it shows that even when things look really dire, there's often a glimmer of hope, a chance for a comeback.
Absolutely. But this wasn't just a stroke of luck for PECPL. They had to navigate a complex legal process, work with creditors, find a suitable investor. It was a team effort, and they had to play their cards right to come out on top.
And that's the lesson here, isn't it? Sometimes what seems like the end is just the beginning of a whole new chapter.
Well said. This has been the deep dive, taking you beyond the headlines and into the intricate world of Indian corporate law. Until next time, keep those thinking caps on and those legal documents in check.